you? Good. Okay, Leah, you have the floor.
Okay. First, I was looking through the stag stuff. Did you guys ever do your deal with David Womack, heating, air conditioning, all that stuff?
Mm-hmm.
Okay. Just wanted to be sure I could cross it off. Did you get the copies of the letter that I sent to the Laborers International Union?
No, not yet.
And what about to Nathan Steinmel on the personal injury?
No. That's the lady that fell in the Justice Center.
Correct. Those are the responses of that. And then here is a draft of a maintenance easement.
We'll have to look over this. I think, did the old one make reference to easement from the center of the road as laid? This says blank feet along and beside the county road located adjacent to and or across grantors above described property.
Correct.
We may have to,
I think according to the statute, that's what you need,
okay.
because you're really wanting to have the easement to maintain those ditch lines and to widen the road, correct?
Mm-hmm.
So the existing road, theory that, I mean, there's nothing that's going to disrupt that, so.
So we have to go and ask for a piece down each side.
Correct.
Which if that gets us our 60 feet total, which is our target, I'm satisfied with that. Okay, what else do you have?
Just wanted to verify, and if we could put on the agenda, or if I need to come when Mr. Fox is scheduled to appear to talk about the special taxes on the municipal contracts.
Right? I don't know that we have him scheduled specifically for that, but we can get something.
Yeah, like next week or something like that. It's
Yeah.
fine. Just
Can
send me.
put that on for next week. Check with Jerry to see which, he seems to like the Tuesday appointment better.
And where are we on the sheriff's inmate fund?
We have it right here. We will just make a motion. We'll make that the last thing we do, make that the motion and adopt that before you leave today.
Okay. And then, I think I talked last, well, maybe I didn't, but I know we talked about the grand jury stuff last time. Which I've gotten the foundation laid on that, went and met with Mr. Banis last week, and I really think it's going to be extremely beneficial for the county and cost effective across the board. So we're supposed to conclude on the 19th, so I'll have a better proposal, but as far as from a budgetary perspective, I think it will go right in line with the budget that's already been allotted for juries. So we'd have a petit jury and a grand jury is the way it would work. So I don't think that will.
Lee, could you just explain grand jury to me a little more than what I know about it?
A grand jury is, well, it's the oldest form of the way law is done. what happens is in a grand jury, you select from a jury pool, same size jury pool, 15% of our voting populace, I believe is what it is. And the judge does what's called voir dire, or jury selection of those. So say our pool is, I think here is 400. So of the 400, he'll pick 60. That's normally about what our numbers are. And he'll bring 60 in, and then he'll conduct the voir dire, the jury selection. So he'll be the judge, the presiding judge will be the one conducting the questioning. That jury will sit for 6 months. So we'll swear in 2 grand juries a year. What then happens is, once the grand jury is selected, they work with the prosecutor's office. The judge no longer sits. He doesn't sit, he doesn't hear the evidence, he doesn't do anything like that. So we might have, say it's child molestation, or say we decided to do drug cases. I don't know if you remember earlier in the year we had 61 warrants that we wrote on a roundup that we did. So in cases like that, instead of having to have our 2 associate judges sit on each preliminary hearing, so those, say that's 60, or the car hopping I used as an example last time, there were 51 victims. Instead of having each one of them come in, we have the officer come in, the officer testifies, the prosecutor goes through the questioning process, the grand jury is allowed to question. They then, after each case, they go back and deliberate for 15 minutes or whatever, decide whether or not there's going to be an indictment or a true bill issued on the individual. If there is, then it basically does away with the phase of the judicial process that involves the preliminary hearing. The other nice thing is, instead of going out and arresting someone and bringing them in and then starting the process, we don't even have to have that stage done. The grand jury either indicts or they don't. If they indict, then we pick them up, and then they're already at the circuit level. So we bypass the entire associate level, which would be fabulous as far as the judicial economy and efficiency's sake in having all these cases come before the court. If the indictment is passed on, then we just start setting it the same way for motions, hearings, for filings and such, and then for a trial, of course. There's a lot of benefits, and the major detriments, and the reason that a lot of counties of ours, not a lot, some counties of our size have elected not to, they're twofold. One is that judges are sometimes reluctant to give up the power, which all of our judges are very excited and accepting of it, and that's not an issue. And the other is, the onus is on the chief prosecutor, so it's a lot more work on my office. But from an efficiency perspective and from a law enforcement perspective, I'm willing to take that burden, because I envision it to be much more efficient than the way we're doing things now. So several years ago they tried to get one in Pike County, and Judge Rush wasn't accepting of the idea. But beyond that, we've not ever had one sit in this county. So, is that?
Yeah, you continue to do your homework on it, and bring us the information, and we're doing a little research on our own. I just printed off a sizable document that kind of
You know what,
talks about grand juries.
I'll email you, if you'd like, a handbook that they use in St. Charles County. It's very easy it's an easy read. It explains the statute, explains the types of cases, and allows you to see how it works, and I've been very well educated now on it, like reading it. It's,
Okay, thank you.
so yeah.
Tom, you got a question?
Yeah, I did. You indicated that the length of the grand jury session might be six months for the impaneled jury.
Correct.
Is there a possibility that you would have a case with multiple presentations where it would exceed that 6-month period, where you'd have to carry over from one to another? Would it be more prudent to have the grand jury, say, for a year to make sure that you've got the case concluded with the proper presentations and so forth?
No, law says that you have to impanel them for 6 months.
Okay,
And it's not just 12. Normally, we would impanel,
right,
say 20.
right.
St. Charles County does 17.
Mhm.
So 20 to me seemed like a
Right.
easier number.
Right.
And then the jurors, if, they're on vacation or whatever the case may be, they decide, either all 20 can come listen, but it only takes 9 to indict. So, you have to have 12 sit, but only 9 to indict. So if, they work their schedules out among themselves, we would probably, at least starting out, only have them sit once a month.
Mhm.
And they would hear several cases in that specific day. But once that evidence is done, then the grand jury doesn't hear anything else about that case. And they have to agree to sit.
What if the jurors have questions that law enforcement has not yet addressed for whatever reason and had to do additional investigation and an additional presentation?
What happens normally, the jurors can ask the law enforcement officer, and they have the right to question at the proceeding, of course.
Mhm.
And so if you're not comfortable, if the juror's not comfortable at the time that the proceeding is over with, to indict, they
And
just
they could
don't
no
indict. Yeah, exactly.
Okay.
The prosecutor would then have the opportunity to file it anyway and take it through the other channel,
Mhm.
but it sort of would be moved. But if the grand jury brought out questions that maybe hadn't been answered and then we found out the answers,
Mhm.
we would have the opportunity to file in case those answers, we felt were maybe better clarified the
Sure.
case.
Okay. That's fine, thank you.
Okay, what else do you have on your list?
We have just recently started a restorative justice program. I think I might have touched on it. Did I talk to you about that?
I've heard the term, not that much.
It's the first time, again, that Lincoln County has done this. We've had it in our juvenile courts, but never in our adult court. In the last 2 weeks, 3 weeks, we've had 2. One of them was the kids in the swimming pool issue at the school. And they sat down with their parents and with the school officials, and they worked out, if you will, a disposition and how the school would be happy and the taxpayers basically would be compensated for the damage that was done, but so that these kids aren't forever tarnished as felons and can go on to college and do things. So that was pretty, we looked at it successfully. Last week, we had a manslaughter case that arrived at I was thrilled with the disposition at the end of the day. It was a dad, father of the victim, who was the girlfriend of the defendant, and they were in a car accident. He had been drinking, she had been drinking, but nonetheless he was behind the wheel. So he had been charged with manslaughter. Obviously that carries with a significant prison term, as well as the young man would be a convicted felon for the rest of his life. So they sat down together and they cried some, they laughed some. Finally at the end, they worked out a disposition. I really feel like it's an amazing program that allows for, in certain situations, some closure for both the victim and the defendant, and allows for accountability, but at the same time gives the victim some peace of mind, if you will. We're mirroring it after Greene County, which is why I'm bringing it up. In Greene County, and this is why, Deanna, for you, they charge a fee. That fee, I think it's $50 or $75. That pays their mediator because they're grant funded. We haven't gotten grants yet. We're in the application process, but we don't have grants at this point. So currently, the defendant pays, if they elect to do the program, they pay the mediator out of their own pocket, whatever the mediator's rate is. What I would like to do is still have the application fee, but maybe not that high. Maybe $20, $25, I don't know. I don't know what the number is. But we talked about it in the in-bank meeting last week, and my concern and their concern was that we want to be able to put together a brochure that then explains